Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Anyway, well then why don't we just stay in Rhode Island since we've been talking about Providence. This is really interesting. And it's interesting because I wish in New York we could do this. So what happened is, and I totally agree, a Rhode Island fire district, correct me if I'm wrong, a Rhode Island fire district had a casino submit a $50 million plan, and the fire department is going to review it, as they should, right? Because look, we've got so many issues with a casino. If there's a hotel, parking garages, look, fire protection's a big deal. And so they're reviewing the plans. The fire district charged them $203,000. That's the part I love, because I don't know how much it really costs, but in any event, they charged $203,000 to review the plan. I wish we could do that here in New York, and we should be able to. The casino argued a couple of things. One, they said, listen, you can't charge us at all. And if you can charge us, you have to stick to the town's valuation and how the town charges, because you're acting under a town ordinance when you're doing this. And the court basically answered very much in the favor of the fire district. One, you absolutely have the authority to review the plans. And two, you are not bound by the town's method of charging. And so your $200,000 bill, have at it. And I thought that was great. I don't know where that comes from in the law in Rhode Island, but that's awesome.
Well, the ability to charge is part of the fire code. Okay, so it's built into the state fire code, and jurisdiction is given to the state fire board of appeal and review. So it's a public body, quasi judicial, I guess. They sit and primarily will hear requests for variances, but they also are statutorily authorized to interpret the fire code. So the courts have to give deference to the way that the fire code is interpreted by the board. And one of the issues here was that the fire code authorizes the state fire marshal to charge for plan review, but it doesn't specifically say anyone other than the state fire marshal. But all of the fire marshals for each of the municipalities are all assistant deputy fire marshals. So there was an interpretation about whether or not the assistant deputy fire marshal for a particular fire district was the state fire marshal. Because again, the way the statute reads, it says the state fire marshal shall. And the Board of Appeal and Review said, yes, that is, okay. And also Lime Rock charged their amount based on the schedule that the state fire marshal charges. And what the allegation was, because of some of the wording in the state fire code, it suggests that it's pursuant to municipal ordinance. So the question was, the town of Lincoln had a municipal ordinance for the plan review of the building inspector. Are they limited to that particular ordinance? Because a fire district doesn't have the authority to issue ordinances. And the state Board of Appeal and Review interpreted that to say, no, whatever regulations that the local fire district creates would be considered an ordinance for the purpose of that. So now the casino didn't particularly care for that decision, so they challenged it. They they didn't even appeal it, which I thought was unusual. They filed a request for a declaratory judgment. And the court first determined that it did in fact have jurisdiction, which again, you would think they would appeal the decision as opposed to, but at any rate, they sought a declaratory judgment, and the Superior Court said no. I mean, the State Board of Appeal and Review is entitled to deference on the interpretation of the fire code, and that's sort of number one. And statutorily and otherwise, we agree with that ruling. So now, who knows? Who knows what our state Supreme Court is going to do if and when the case ends up getting to them. So, right. But it's a pretty big deal for the folks in Rhode Island. Outside of Rhode Island, it's really not. Yeah.
Well, and if it's overturned, right? If they lost on appeal, here would be the hard part, because now presumably all these districts are going to start charging the fair value of their reviews, and if that's overturned, that they can't. Wow.
Yeah,
Um,
hopefully the Supreme Court, if it gets there, is going to do the right thing for fire departments anyway. Because you can say, oh, $203,000 is is an enormous amount, and it no doubt is, but that may require them hiring someone to go in there and do a lot of the inspections and code enforcement stuff. And they may actually have to retain like an engineer, because, you start thinking about casinos aren't compartmentized. You think about the casino near your house, up where we do your conferences, Turning Stone, and you have that just wide open atrium where all the machines are and everything. Plus you've got theaters and bars and restaurants.
Parking garages where there's going to be electric vehicles, and people are like, Appendix D, I think, to the Fire and Life Safety Code is turnarounds for aerials and vehicles. So you're measuring parking, right, turnarounds and where spaces are. It is an intense process. I say that only because I participated in the evaluation of a turnaround, and it took us a full day just to look at one turnaround as we're moving the aerial around. And I mean, it was insane what the engineers go through. So it is a ton of work. I totally get it.